Beryl Howell gave a scalpeled ruling where she carefully crafted explanations of where the speech or debate clause applies and prevents the Department of Justice from accessing Scott Perry's phone on which particular matters. She borrowed from Judge Ruth Bader Ginsburg's ruling about how the issue at hand is about the matter at hand and not about the actor. The key consideration, Justice Ruth Bader Ginsburg said, was Supreme Court's decisions teach that the key consideration is the act presented for examination, not the actor. So while the speech and debate clause protections apply and provide absolute privilege when they apply, the bigger question is when the speech or debate clause applies. And the 51-page opinion by Judge Howell explains in which circumstances, in which legislative purposes, legislative acts, and among whom these communications between members of Congress and others, who these others are, where the privileges apply or they don't apply. And as a general matter, perhaps the message is that the speech and debates clause protections, when they apply, are absolute, but when they apply is the bigger question. And they definitely do not apply when the member of Congress has communicated with a member of the executive branch. And this to me is very important, both for Scott Perry's ruling in this Judge Howell case, but also with the speech and debate clause case that Jack Smith is now pursuing against Mike Pence. I don't know if you're going to see that ruling or not, but I would suspect that this idea will come up. That, first of all, the position of Mike Pence straddles both the branches. So how do you assess what part of what branch he is, or whether he can even enjoy this privilege? And should the court decide that yes, he can, the question becomes when he can. And the question becomes when he can, the act presented, not the actor. So the focus is on the ministerial functions of Mike Pence, over which this privilege would apply, which is even narrower, and the claim, therefore, of speech or debate clause is even weaker because Mike Pence's legislative function or role is ministerial and limited to counting electoral votes in a prescribed manner. And then the tie-breaking vote should the Senate ever get to 50-50. So the limitations provided here, where Mike Pence is both a member of the executive branch and in the act presented for examination, the particular acts for which the DOJ would go after Mike Pence, where Mike Pence can raise the speech and debate clause, would depend on his legislative function and the scope of his own legislative duties, which are narrow in scope. Therefore, his privilege would attach only to those legislative functions and communications as it pertained to those legislative functions, such as speaking with a parliamentarian about the language, talking about how he was going to implement those procedures. But anything outside of that, especially communications that he may have had with other members of the executive branch, his speech and debate clause protections do not apply there. If he is a congressional officer raising a congressional immunity in his role as a ministerial congressional officer. His communications to Donald Trump and executive branch officials in his capacity as a congressional officer are not shielded by the speech and debate clause. And then we have the executive privilege argument on the other side of it. I'm not going to go into the executive privilege argument at all today. So I wanted to tie this up with carrying, I believe that the DC Circuit, which already had the oral arguments on this case, will side with Judge Beryl Howell, because she even followed the DC Circuit's procedure of not letting the law enforcement agencies access the documents until this ruling came out, and she made a review of which documents, her court made a review of which documents would fall under this privilege or not. So there's no abuse of discretion claim whatsoever. In terms of the substantive matter, Judge Howell follows DC Circuit precedent. Judge Howell discusses how the 11th Circuit's procedures are different, and brings out precedent from the Supreme Court that gives out limitations of the speech and debate clause, and clarifies that while the speech or debate clause has absolute protections when it applies, the question of when it applies is the more pertinent and judicially important question for the court to answer. And that's what precedent says. And that's what Judge Howell has done here. I believe that Scott Perry's phone will be accessed by the DOJ. DOJ will get these documents. And I believe that this opinion and this proceeding and this logic will be instructive for the DOJ as it pursues its speech or debate clause claims against Mike Pence.